Living as a religious person in Canada today means facing various crossroads of choice due to ever-changing societal trends. Bill C-9, currently under discussion in Canada, was proposed with the stated aim of protecting communities from hate crimes. However, upon closer examination of this bill, religious communities, including the Church, have raised concerns that it could significantly curtail freedom of expression and belief. Controversy reached its peak when, in late 2025, a House of Commons committee resolved to remove the defense based on bona fide religious belief. Should this bill pass, the primary disadvantages churches in Canada could face are as follows. First, the removal of the bona fide religious defense. Currently, Section 319(3) of the Canadian Criminal Code provides a protective shield. If someone expresses their beliefs in good faith based on religious texts, specifically the Bible, they are exempt from punishment for hate speech. If this provision is removed, quoting specific Bible verses or preaching traditional Christian values, such as marriage or sexual ethics, could significantly increase the risk of being accused of hate promotion, depending on the context. Consequently, even if a pastor faithfully delivers biblical teachings from the pulpit, if someone perceives it as hateful and files a complaint, they would lose a crucial legal defense in court. The second issue is the simplification of prosecution procedures. Previously, prosecuting hate speech required mandatory approval from the provincial attorney general. This served as a safeguard against frivolous complaints. Bill C-9 seeks to abolish this ministerial approval process. Consequently, anyone could file frivolous complaints against churches, and police or prosecutors could immediately launch investigations based on political judgments or public complaints. Even if acquitted, churches would bear enormous legal costs and suffer significant reputational damage. Under this bill, evangelism outside churches or peaceful religious demonstrations in public spaces could potentially be interpreted as threatening others or obstructing access. Consequently, it instills fear that the very act of expressing religious beliefs externally could become subject to criminal punishment, inducing self-censorship. Finally, it opens the door to subjective judicial interpretation. The state would determine whether religious teachings constitute hate speech. Consequently, biblical passages or theological debates could be branded as hate crimes based on judicial standards. This undermines the principle of separation of church and state and risks the state judging religious doctrine. To summarize the points made thus far, the practical risks churches would face if this law passes are as follows. First, proclaiming biblical values risks being deemed hate speech. Second, legal costs will increase. Unwarranted complaints will lead to litigation expenses and wasted administrative resources. Third, evangelism activities will be restricted. Expressing faith in public places could be perceived as a threat. Finally, freedom of religion will be undermined. The state will create a structure where it judges the legitimacy of biblical interpretation. Connecting this to the issue with the Canadian Presbyterian Church mentioned previously, churches remaining in the denomination might consider it fortunate to avoid such problems. However, this also means that for the churches remaining, their freedom of conscience, the very reason they stayed, is being taken away by Canada's legal amendment. What is their position? And for the churches that left the denomination, upholding the truth of God's word may require even greater sacrifice. What is their position?